Good morning, everyone. Welcome to today's webinar. I have the pleasure of being here with Robert Blanche with Siegfried and Rivera. We're going to give everyone about a minute or two before we get the webinar started. In today's webinar, we're going to be going over all the legislative changes that have occurred this past year. There are some bills that are still being signed as we speak. But Robert Blanche today will go over most of the changes that are going to impact our associations. There are many, so he may not be able to get through all of them. But we'll do our best to go through most of them. After the webinar, we'll be glad to share, or I should say the Siegfried will share with you all the changes and what you can expect for your association. So we'll give it about a minute and then we'll get started. If you have any questions that may come up throughout the webinar, please don't hesitate to use the Q&A. We'll do our best to address those questions. If there are questions that aren't related to today's topic, we'll see if we can address them at the end of today's call. If not, we'll do our best to get them addressed after the call. So again, if you'd like to use the Q&A function, please feel free to do so. We will be monitoring it throughout the webinar. So Robbie, I think we're good to get started. It looks like the numbers of participants have evened out. So if you don't mind, maybe telling our guests a little bit about yourself, a little bit about the firm, and the topic that we'll be discussing today.
Sure. First of all, Rafael, I'd like to also thank you guys at Affinity for inviting us often to have the opportunity to present to our collective group of listeners and participants. We started on these platforms about a year and a half ago. And,
yep.
and I think we're getting the hang of this. So we do have very good material here today, and not too much time within which to present it. Nonetheless, we're going to do our best to give an overview of what the legislature has adopted this year by way of new legislation affecting community associations and what the governor has been signing into law. My name, as you all are aware, Roberto Blanche, Siegfried Rivera. Our firm has been around for many years, 40 years plus. Even though I haven't been around that long, I've been doing this for just 20 years. And my practice is focused exclusively on representing community associations, condos, homeowner associations, HOAs. I do any type of, we handle any type of issues for the associations, from the mundane, excessively loud barking dog demand letter to the more complex opinion letters and contractual issues that we encounter on behalf of our clients. Including collections of assessments, enforcement actions, you name it, we do it. 3 offices located in Dade, Broward, and Palm Beach counties. So our clients stem from Central Florida down to the Florida Keys, predominantly on the East Coast. And that has afforded us the opportunity to become very intimately aware of the types of issues that community association stakeholders, I refer to them as stakeholders because it's the lawyers, it's the managers, it's the board members, it's the unit owners, it's the vendors, the renters, the guests of people that are occupying units within community associations. These are all the stakeholders who are affected by what it is we do and what it is you do, Rafael, and Affinity. And, so with this legislative session that has passed us by, a pretty active one from the perspective of community associations, we can provide some insight to associations and its participants or their participants on what the impact of this session may be.
Excellent. Thank you so much for that introduction. And as you stated, Robert, it's the same pleasure as well to do this webinar with you and your firm. The wealth of information that you guys provide always benefits the mutual clients that we have. So we're very appreciative of you, as well as the team that works behind the scenes to make you and I look good. So we want to thank them as well for their efforts. For the board members and managers that are here today, again, we want to thank you for being here today and taking really that big step of moving things forward within your community and gaining as much knowledge as possible to be able to lead your community in the right direction. There's been a lot of changes this year compared to other years, at least, it feels that way. There's been a lot of positive change. There's been some changes that we need to pay very close attention to, because these changes do come into effect come July 1st, so which is less than a week. So with that said, I'll let you go ahead and start off, Robert, and maybe start giving them some of the bills that you believe are going to impact our associations.
Sure. We're going to dive right in to a topic that is, I believe, very relevant to what we all have been experiencing for the last year and a half, and that is that area of the law that concerns what it is that an association may or may not be exposed to as it relates to liability for damage or injury related to COVID. And so very early on in the legislative session, there was a bill presented in the Senate, approved by both houses and signed into law by the governor, which was Senate Bill 72. And it is a very short bill. It's a 13-page bill, but what it effectively does is it provides some immunity, so to speak, for property owners, for commercial establishments, and included within all of that is community associations. And the protection is to protect against these entities, or to protect these entities against liability that may stem from COVID-related damage or injury that a plaintiff may assert, provided that these entities, I would say, did not act grossly negligent. Now, the concept of gross negligence is a very large hurdle to overcome. And so this bill includes certain safeguards that require some type of medical showing that the injury came from a certain place, and then there needs to be a judicial finding that as to the plaintiff's allegations made, and that they came from a particular location. Once the judge feels comfortable that that threshold has been met, then the ball kind of goes into the association's court. Let's use an association hypothetically as the defendant in these particular cases. The association would merely have to show that it did not act grossly negligent. And while acting grossly negligent is a very difficult hurdle to overcome, I refer to this particular bill as still providing our clients, your clients, with some type of, I don't want to say excuse, but justification, let's say, to keep reasonable safeguards and measures in place to protect against the COVID virus. And so while we look around and we see places opening up and amenities being more freely used, and people feeling more free to remove their masks, etc., we look to this bill to tell our clients, extend the leash a little bit more, loosen up the rules a little bit, but don't just eliminate everything. We still need to do what might be considered to be reasonable, because if we do that, then we should easily be able to overcome a challenge by a plaintiff that whatever measures we took were grossly negligent, or whatever measures we didn't take render us to be grossly negligent and therefore liable for injury or damage that may have been sustained by that plaintiff in connection with an infection or a sustained infection in a community association. So summary of Senate Bill 772 is that we still keep whatever is, quote, reasonable in place, even while we are being allowed to loosen things up. This is a word to the wise: don't just eliminate all restrictions altogether.
Correct. And I think we're both on the same page there. We've seen, you always have two extremes depending on the risk factors, the measure, how much risk the board is willing to take. We've seen a lot of boards where they've lifted most of the protocols, but they still remain with certain things like making sure they have, the sanitizing machines by the pool area, making sure that people are still wiping down as they should, because the virus is still out there. Now, as you stated earlier, you said it very nicely. It's, definitely releasing some of the rules. We're in the midst of summer. You have people that have been locked up for about a year and a half, but it's important that at the end of the day, we still have some form of responsibility. The bill did help our industry out drastically because, things could have gone the wrong way if it wouldn't have passed. So we've seen many changes, but as you stated, it's very important that at least you keep an eye that it's still out there, and you keep certain things like at least having those sanitizing machine, having your cleaning individuals doing what they need to do.
Yes, I want to remind you and all the listeners that we will have available a synopsis of all of these bills that I discussed. We opted not to provide a slide presentation because there's just way too much material to effectively run through a slide presentation and to provide in advance. So the next bill, which is Senate Bill 630, 101 pages of material, and I'm going to do my best to run through a condensed version of it because there is a lot of material that is included in this bill. This bill starts off with addressing subrogation. So remember, it's Senate Bill 630, signed into law by the governor, effective July 1st, 2021. So come July 1st, everything I'm discussing regarding Senate Bill 630 will become applicable law for all of our community association clients. So subrogation and many associations are impacted by subrogation actions filed by the insurance companies that represent or that insure the unit owners. So a unit owner may have some event, some casualty or insured event. Their insurance company pays on the policy. And then what that insurance company does is it files a subrogation action against the association's insurer for recovery for what that company suspects, feels, or argues the association should be responsible for. And so as a result, you've got a flurry of subrogation claims, which those insurers, those few insurers that provide insurance coverage to our community associations, predominantly the condos and the HOAs, strike out the condos and the co-ops, have to defend against. And so those types of cases are oftentimes cited as one of the reasons why insurance premiums continue to go up. So what the legislature did is they said, look, if the association's insurance policy provides that it will not subrogate against owners, then unit owner policies must provide that they cannot subrogate against the association in these cases. So it's going to be what's good for the goose is good for the gander from a subrogation perspective, pursuant to the changes implemented into Chapter 627 Florida statutes resulting from Senate Bill 630. Within this bill, we now move on to Chapter 718, 719, and 720. There are a bunch of changes that took place, most of which are applicable to the three community association chapters. And the first of which, affecting Chapter 718, is a revision to the official records provision. We all know that we got to keep a ton of official records, and we know that we were supposed to keep bids, right? We're oftentimes required to obtain bids by law for some types of services and work that our clients are going to have implemented in the condominium. And so those bids had to be maintained for many, many years. The legislature has reduced that so that you need to keep the bid for a period of 1 year. As to official records, 718 is now modified to clarify or to expand that for condos that have 150 units or more, we know that they needed to have a website as a result of legislative sessions implemented a few years ago. Now the legislature says you can have either a website or an app, some type of application that can be accessible via phones or tablets or computers in lieu of a website. The provisions of 718, 719, and 720 have also been amended to provide clarification as to something that was legislatively enacted a year or two ago, which allowed in Chapter 712, Section 712.065, allowed for documents, like restrictive covenants, declarations of condominium, to be amended by the board alone in order to remove provisions of those documents that had a discriminatory impact. And so some of your older communities, you don't find a lot of this in the newer communities because times obviously are different. But in some of your older communities, you would find some restrictions that were very bluntly and blatantly discriminatory. Well, the legislature a few years ago allowed us to change those provisions, and now has extended that clarification to condos, co-ops, and HOAs vis-a-vis changes to 718, 719, and 720 to provide for the extinguishment of discriminatory restrictions. If you remember a few years back, Ralph, there was this establishment of an 8-year limitation, right? Term limits for condo association board members. And so if they served on a board for a period of 8 consecutive years, they were deemed to be ineligible to be on the board. Well, there was a lot of to do with when do you start counting those 8 years. There were declaratory statements filed with the Division of Condominium, and the Division of Condominium did an about face. They flip-flopped on this issue, and they initially said that you count retroactively the 8 years, and then they kind of like took it back and said, wait a minute, we're just kidding. It starts
when the law passed
July 1st of 2018. So what the legislature did is they said, you know what, we're going to make this abundantly clear so that the Division of Condominium doesn't have to take matters into its own hands anymore. And so what the legislature did is they provided clarification in that provision of 718 to specify that those 8 years start counting as of July 1st, 2018. Another really impressive change that they did and I say impressive, not that the world in general will find this to be impressive, but some of us that deal with community associations all the time may find it impressive, and that is transfer fees have been increased or the cap on transfer fees have been increased from $100 to $150 for condo association. As you know, any fee that is imposed by an association in connection with the transfer of that unit or the transfer of occupancy of that unit is capped at $100. $100 now, as of July 1st, 2021, that limitation has been increased to $150. And every 5 years, that's going to be able to be increased depending upon the increases in the CPI. So the legislature did provide for the ability to increase that by virtue of any increases there may be in the consumer price index. There was also a few years ago certain restrictions embedded upon directors being able to, condo associations being able to sign contracts with companies that a board member may have had some type of ownership interest in. Well, that restriction in 718 has been lifted. So it's not to say that the association is free from conflicts of interest, but now the association would have to clear those conflicts of interest through the standard conflict of interest checklist that you can find in Chapter 617 Florida statutes, as well as the other provisions that you find in Chapter 718. We know about electric vehicles, right, Ralph? We know that in many of the communities that we represent, there is this, the legislature has made a push to encourage electric vehicle charging stations. And they've clarified that the installation of electric vehicle charging stations by the association does not result in a material alteration. They've established legislation years ago a couple years ago, if not last year, to clarify that if an owner wants to install a electric vehicle charging station within their parking space, the association cannot stand in the way of that. The association cannot prevent that. We can condition it on certain conditions that the statute itself deems acceptable, but we cannot prevent an owner, to the extent he or she complies with those conditions, from installing an electric vehicle charging station. Well, interestingly enough, what the legislature did this year is that they broadened that provision not only to electrical vehicle charging stations, but now they say that you cannot prevent the installation of natural gas fueling stations or pumps. So I don't, whoever, I guess there may be a whole other industry now.
Yeah.
For natural gas fueled vehicles. But in our condo associations, we're not going to be able to prevent an owner from installing a natural gas fueling pump or station within their parking space. I don't know how they're going to get that done, because I think some of these parking spaces are barely large enough to fit
an SUV or any car. Yeah.
But anyway, I guess if you can manage to squeeze it in there, you can do it, and we can't stand in the way of it. In section 718.1255, that section deals with dispute resolution in condominium associations, and that's where you find all of this language regarding mandatory arbitration. Well, now in this bill, and in Senate Bill 630, there are a bunch of areas within Chapter 718 and 719 and 720 where the legislature has provided for additional options with regard to the resolution of disputes. They're encouraging voluntary mediation, where mandatory arbitration was the only option. Now mediation is encouraged, and they're also providing for the option in many of these disputes, if not all of them, to just go straight to court. So whereas before you were able to, you had to go to arbitration, now you can go to arbitration, or you can go straight to court, if the parties agree to a lot of these things. So, this is to be taken into consideration, because even though I understand the court systems now might be somewhat sluggish in light of the impacts of the pandemic, prior to the pandemic, comparatively speaking, the courts, even though it may not have been the case at the beginning, when these statutes were enacted, the courts more recently than not have been a little more efficient than the arbitration over at the division of condominiums. So we do find that there has been somewhat of an expansion of where litigants may go to resolve their disputes.
Excellent. I have a question here, Robert, with regards, I guess, back to the application portion of it. We have Katya's asking, so she asked, so lease applications can now be charged $150 instead of the $100.
Effective July 1st.
July 1st, exactly.
The limitation on transfer fees effective July 1st has gone up from 100 to 150.
Correct. And as Robert stated, that they were smart this time around, right? Because this has been a fight for many years to increase that fee, and they finally made it happen. And at least they were smart enough this time to add the CPI over the next 5 years, I believe it is, that now they can increase it yearly. So that is something to keep in mind, and that is good work that they did here. I have another question here from Eva that has to do with, I believe it has to do with the electric vehicles and also the natural gas. It says here, is this true even if a unit owner is just assigned their space? Okay, I guess she's asking if the space is either assigned or deeded, does it matter that the association still has to provide access or to that individual to either put an electric vehicle station or a natural gas station?
This would apply to a limited common element parking space. So if the association provided the use of a parking space, but that use is not consistent with limited common element exclusive use. Okay, so if it was like a lease or some shorter term assignment, that would not apply. This would apply to a limited common element assignment, which is what you find in most of the condos, right? A unit owner in most condos has the limited common element pertinent use of at least one parking space. So within that one parking space, if that individual wants to pay for it, make sure from an engineering perspective it's done in the appropriate manner, that it's sub-metered, there are a bunch of conditions within the statute that an association cannot prevent him or her from doing that.
Correct. Excellent. And what I do want to add to that is keep in mind for both board members and managers that you should be consulting with your attorney whenever you're going through this process. Ultimately, if you get the request and you don't have the protocols in place or the policies or procedures in place, hopefully you do it before that request comes in. But this is something that you should already start considering, especially in the age that we're in, where everyone's pretty much moving to electric vehicle. I mean, now you have an F-150 that's an electric vehicle. So it's moving in that direction. So it's going to impact your associations. So you should already consult with your attorney, come together with the procedures, the protocols. And that way, when that request comes to fruition, you already have all your ducks in a row to be able to address it. I knew this would be an issue. Not an issue, but we get a lot of questions again about the application. So does the $150 transfer fee apply for processing a lease? Jackie, the $150 is basically no different than if you were charging a $100 application fee. It's just now you're permitted to charge a $150 fee. It still remains that's the cap rate. I know some board members are getting creative or wanting to charge $150 on top of what they're charging. It's basically a max of $150 now rather than the $100 that the statute had. I have a great question here, Robert, from Martin. It has to do with now that they clarified the staggered terms and when the 8 years start. Did they make any changes with regards to if it goes further than 8 years, or did it remain that they still have to follow that same process? Assuming that no one runs for the board or a certain vote that's required to go further than the 8 years. Did that change at all?
No, the statute, those restrictions all stayed the same. And so what you look at is if a director, as of July 1st, 2018, if a director has served from that day forward, so we're going 18, 19, 20, 21, 22, 23, 24, 25, 26, so until 26, right? 2026 will be the first time that we'll start dealing with this because that's when the 8 years from 2018 will apply. The only way you can get around the 8-year limitation is if nobody else is running for the board, right? So if there are no if the number of candidates does not exceed the number of upcoming vacancies. That's one way. The other way is if 2/3 of the owners or the eligible voters, if 2/3 of the eligible voters voting at the election vote to elect that particular director, then the 8-year cap will not apply. And that would have to happen every single year. So the 8 years is something that you'll never be able to get away from. We can't extend that. A condo cannot vote to allow for it beyond 8 years. You cannot amend your governing documents to allow for more than 8 years. However, the eligible voters voting at an election can vote by 2/3 or more to elect that individual, and if he or she receives more than 2/3 of the votes from the eligible voters at the election, then he or she may continue to serve on the board beyond the 8-year cap.
Excellent. And I'll ask you one more, Robbie, and then I'll let you keep going. Does the changes in the arbitration, the option that they have, does that apply for HOAs or is that just for condos?
Well, most of them, with regard to arbitration, that would apply only to condos because HOAs were not required to go through mandatory arbitration. HOAs do have pre-suit mediation that they need to follow, but what you found in what they've done legislatively to the condos is to give a little bit more of the flexibility that you find in the HOAs. And then with regard to the HOA, they've also given the right to just go to court on some other issues. So there is an amplification or a broadening, let's say, of the available remedies in community associations generally. In condos, since they were more restricted to go through mandatory arbitration with the division of condominium, that has been loosened up somewhat. So we'll keep that in mind for those communities pursuing enforcement action against their owners or tenants. And this takes us, Ralph, to another aspect that we find legislatively changed in Senate Bill 630, and that is this whole concept of emergency powers, which again stems from the division, stems from the pandemic and the impacts of the pandemic from the perspective that during the onset, we were really focusing on the emergency powers and a lot of the restrictions that we enacted in community associations. We did so basing our right to do so upon the emergency powers that we find in the 3 community association statutory chapters. Well, what those applicable provisions did, and those are included in 718.1265, 719.128, and 720.316. Those sections have now been expanded to not only address damage, right? So you were able to adopt certain emergency powers to protect against damage. Now they've been expanded not only to protect against damage, but also damage or injury.
Yeah.
And that's important. It also allows for phone, video, or other real-time meetings and elections. And it clarifies that, whereas before that wasn't so clear or it wasn't the case. It expands a list of officials that an association may rely upon with regard to having the justification for implementing emergency plans. Because now we've got the CDC and all these other people. Before we were just worried about the emergency operating center, maybe the governor. And now we can follow the guidance from other quote officials. It allows for clarified restrictions of access. So we now have the justification to restrict certain types of access into the community to protect against these injury or conditions that might cause damage or injury. Allows for action to mitigate not only damage, but also injury or contagion. It allows us to contract with vendors and companies to protect against injury or contagion and to sanitize. You see all of these buzzwords that are more pandemic focused than hurricane focused, which is what 718, what the emergency powers used to mainly be for. Protects right of access to units for ingress and egress in connection with the sale, lease, transfer of units, and the habitability of the unit. Okay, so at the beginning, there was some debate as to the extent to which an association may prevent or hold up sales, leases, transfers of units, people to be able to live within their units. So some protections now with regard to the owners and their ability to be able to transfer their units. So that's something to be kept in consideration. There has been a minor change to 718.202 regarding the sale or reservation deposits prior to closing and how developers can use those. I mean, we'll kind of skip through that. 719 was modified to clarify that a unit in a co-op is actually an interest in real estate. With regard to co-ops, the rules and regulations have been removed from the definition of what is a cooperative document. In Chapter 720 Florida statutes, there has been a revision to 720.303 to allow for the establishment of procedures for posting notice of board meetings on the website or the app. Also, with regard to official records in HOAs, the ballots, sign-in sheets, proxies, and electronic records are to be maintained for 1 year from the election or the vote or the meeting. And if you know that there is a list of protected official records, documents that must be kept as part of the official records, but nonetheless may not be inspected by other owners. Well, included within that, you cannot see it list are the information in an HOA that is obtained in connection with a gated community for guest visits to a parcel owner or community residents. So that log of who's coming in to visit an owner or a resident is no longer accessible generally to owners vis-a-vis the official records inspection provisions. Clarification with regard to the disclaimer for HOA budgets when you're not adopting full reserves, let's be on the lookout for that. There's a removal of the provision required to establish reserves by the developer and creates a new section. So if you remember, before, if the developer created reserves, then an association was obligated to continue with those. Well, that kind of has been modified somewhat by the legislature. There are provisions that create a grandfathering mechanism similar to what you find in the Condo Act whenever you're going to make amendments to the leasing restrictions in a community. Yeah. You know that in 718, when you're talking about condominium associations, there are some types of amendments that impact the ability to lease a unit that require associations to grandfather existing unit owners. Well, there is a similar change, though there are some nuances that we need to pay attention to that have been established in section 720.306H Florida statutes. So that takes us through Senate Bill 630 as quickly as we can. The good news is that we've got really one more bill that I'm going to tell you I think is really critical, and that is Senate Bill 56. And then we've got some others that have also been adopted, but we can really zip through those. I don't know if you've got any questions, Ralph, or if you want.
Yeah, most definitely. I have a couple questions here. So there's a follow-up from Martin. It says, with regards to the 8 years, how long is it extended for? So I guess if the membership if there was a 2/3 vote, or if there isn't enough vacancy, are there any restrictions on how much longer they can serve, or would it reset to another 8 years?
No, it doesn't reset. That candidate is just given the opportunity to serve that year. So he or she would be able to serve their 9th year. And then when they're going to be reelected again, they'll have to get the 2/3 vote again, unless there aren't any candidates, and if he or she is the only board candidate or one of the only ones below, as you know, if you've got, for example, a 3-person board, but you only get 3 candidates, there's no need for an election. So if those 3 candidates have served on the board for 20 years, we're not going to restrict them because nobody else really stepped up to the plate.
Correct.
What the legislature did when they enacted these term limits is they said, look, let's give other people a chance.
Correct.
If there are other people that want to be on the board and they're willing to do it, then let's give them a chance. But then they also said, you know what, we understand that Director X might be really good and popular and the people may want him or her, irrespective of whether he or she may have served 20, 30 years, so let's let them serve. We're going to do that if they get the vote of at least 2/3 of the eligible voters voting at the election.
Of course. Yeah, no, it makes sense. It gives both parties the opportunity to do what they need to do. I have a question here from Lisa. So basically, Lisa asked for the electric car charger option. Let's say an owner doesn't have a parking space, an assigned space, and just has only a mandated valet space. Do they still have to give that individual the option of if they want to have their vehicle plugged in?
No.
Okay.
Now you'll find associations are installing these stations or contracting with companies and vendors to install these stations uh, at the common elements. And so in those cases, but that is discretionary. There's no
Yeah.
mandate, there's no requirement for an association to do
Correct. Yeah, and
that.
I've seen the same. Like Robert mentioned, you're seeing it as an amenity now to some buildings, which makes your building a little bit more marketable. No different than, let's say, if you added a kid's playground and you didn't have one. Some buildings are deciding to maybe put in these charging stations just to make their buildings a little bit more popular in essence of what they're offering, what their service offerings are for new owners. With regards to, I have here a couple notes that I think it's important to highlight. I think especially for the portfolio or those accounts that, you have some associations that have a tough time, making the investment into a website. That web portal definitely does help many associations to be able to provide the necessary information. And with most tools that most management companies use nowadays, there is the option of that app, which is also known a web portal, whatever term or whichever way it gets coined for that particular software. That does provide a lot more transparency for the residents. So if you don't want to opt for the website, I think that change definitely did impact in a positive way our industry. So at least we can provide the information that's necessary to those residents. I did want to ask you, Robbie, with regards to the having the meetings, because COVID had its many challenges, but it did bring some benefits where it really fast forward the technology side of things for our industry. And in its own way, our industry has kind of been a little bit, dragging its feet and moving forward. However, COVID has definitely sped up a lot of these things, especially on the technology front. When it comes to board meetings, I'm finding that a lot of board members still want to continue to host their board meetings online. They're following the proper protocol with regards to noticing it. We've always, at least from our side, we've always emailed the agendas and so forth. What's your take on moving forward? Now that things are opening up, some residents just don't want to. You have those older folks or some residents that don't want to. They want to physically be there. What's your recommendation with regards to board meetings and hosting them online through Zoom and so forth?
Well, I mean, I think that if you have the ability to allow for in-person attendance and you can do it in a safe way, you could do it in a way that does not compromise the health of those that are going to be physically present, then I would be encouraging of it. I
Yeah.
encourage allowing for in-person attendance if it can be done in a safe way. Um, Alternatively, I think you still have the ability, especially given the fact that, we're still in a pandemic state, to justify keeping it closed. But I think it really depends on the factors within your particular community and whether or not you can accommodate an in-person meeting versus a remote meeting or a virtual meeting. And of course, I'm not suggesting that the board members themselves or management be forced to come in. If there could be a way to do it without that type of a requirement. So, for example, you could imagine a TV or some type of monitor set up in a room where you see, all of the participants that are virtually attending. And then within the room, you've opened it up so that some people that want to be physically there have the ability to participate. If
Correct.
that can be accommodated, then I think you've checked off all the boxes.
Correct. And that's exactly what you said was what we've been seeing. We have one particular association that they've done it just like that. They, TVs now are pretty cheap. They bought themselves a 65-inch TV. They have a committee member that just comes in, pops open the laptop, turns it on, and the entire board is really on Zoom, and they're seeing the entire board. They give everyone the 3-minute option. There's a small microphone installed, and it gives everyone the option to participate, no different than if it was a regular board meeting. We have found that it's been much more efficient for both when we're hiring the attorney to come in to help, because the attorney is just charging for the time that he or she is there. They don't have travel time expense. It's been a major benefit for the manager and the quality of life for the managers, because they're able to go home, do what they need to do with their kids, jump on a meeting for about an hour and a half, and then continue their lives with their families. And the same thing goes for board members. Have that comfort of being at your home. if you're an investor and you're out sit on the board, you don't have to worry about traveling a certain distance. So I'm hopeful that it stays, hosting these board meetings online, because we've seen, major benefits, especially for quality of life for our team members and our board members alike. I have another question here, Robbie. It says, do rules have to be recorded? I heard that it's being excluded from the DCCR changes.
Yeah, you don't, for condos and for homeowner associations and co-ops, the rules do not have to be recorded.
Okay, excellent. I have one
Now,
more from you. Sorry, go ahead.
My suggestion, however, is that if there are versions of those rules that are recorded, I like to continue recording them, because if you have somebody that is taking title or acquiring a unit in the community and all they've done is looked at what's recorded, then they may be unaware of any rules that may have subsequently been adopted if they're not recorded. So once, I think, as a matter of practice, once you've recorded, I think you should continue to record. But if you haven't recorded, then there's no per se requirement to do so.
Okay. And I have one more before I let you continue going. I have here a question. I guess she missed the part of the DBPR. So she wants to know, what's the change that happened with the DBPR and the courts? If you can kind of re-clarify the differences.
I mean, I'm not really.
I believe I think she's referencing with regards to, instead of going to mediation or arbitration, you can go straight to.
Okay.
Yeah.
So no, all I was saying is that within Senate Bill 630, you find a lot of instances in which the legislature has made an effort to expand upon the options that parties to a dispute may have as to what venue they're going to address the dispute in. And so, by example, in a condominium, there were some types of disputes defined within the statute 718-1255 as to having to go to arbitration. We were obligated to go to arbitration, and now what you'll find is in a lot of these provisions, there has been an expanding of the options that you have. If the parties want to go straight to court, there are provisions addressing that. If the parties prefer to go to mandatory or pre-suit mediation, voluntary pre-suit mediation, as is also the case in Chapter 720 Florida statutes, then these legislative changes are encouraging of that as well. There has been a lot of noise over the last few years about what some people perceive to be inefficiencies with the division of condominium and how long it's been taking for them to resolve certain cases. There are also people that are under the perception that the division of condominium has been reluctant to take cases, even those cases that statutorily it is obligated to take. And so you hear a lot of I don't want to say excuses. You hear a lot of explanations or justifications for that. Some might be that they just are overwhelmed and don't have the resources with which to address some of these disputes. And so, with all of that said and done, this round of legislative changes enacted through Senate Bill 630, effective July 1st, have given us those more broad options to look for or to look toward as it relates to the resolving of disputes that we may encounter, or the pursuit of remedies that we might have to our availability.
Okay. And I know I said that was the last one, but this one popped up with regards to the recording. I guess we should clarify it. So there are some questions from David and Matthew with regards to the rules and changes that we just discussed prior to this question. David asked here, do all rules / changes have to go through the DBPR? And then Matthew kind of asked, where do they need to be recorded, if they need to be recorded?
When you're amending rules and regulations for a community, HOAs don't have to go to the DBPR. So what we're going to call a division of condominium, which is a subset or an agency within or a division within the DBPR. So with regard to HOAs, don't worry about it. With regard to condos and co-ops, when you are amending rules and regulations for living within the community or how you interact within the community, those rules and regulations our board of directors can adopt from time to time and amend from time to time. Those don't have to go to the DBPR. Those don't have to go to the division. In some instances, the question that was asked earlier is, do you need to record them? When we talk about recording, we're referencing recording them at the public records for the county in which the property is located, which is different than the DBPR. So do you need to record these amendments or these new rules and regulations? The answer is, in most instances, no. However, in some cases, historically, those rules may have been recorded. So I find it to be good practice to, if you've got some rules that have been recorded, I find it to be good practice to record any amendments or revisions to those rules so that you continue to provide the public continued awareness of the extent to which that particular rule may have changed. So that's all I think we touched upon with regard to the amendment of the rules. I think, Ralph, we should touch upon Senate Bill 56.
Yep.
Which is, I think, pretty relevant to most of our clients and most of the participants here, because this one too was signed into law and is effective July 1st, 2021. And what it does is it creates certain revisions to aspects of community association transactions related to the collection of assessments from our constituents, from owners. First and foremost, it talks about the method of notifying members of what they owe, right? So we talk about this affirmative statement or the method of sending out statements or invoices of assessments. In some communities, it's done by email. In some communities, statements are not sent. In some communities, they're sent out by mail. So if you're going to change the way you send out your invoices or your statements of account, what this revision now does is it says that you need to notify the members that you're changing that method of communicating the invoices or statements of account. So if you're going to go from written statements to emailed statements, you need to give a 30-day notice by first-class mail to all of your members, and you need to get an affirmative acknowledgement from that individual, basically saying, hey, yeah, I'm aware of this. You've told me that you're going to start sending it instead of in writing, you're going to send it out by mail. What I find to be a little, concerning here is that, I don't know how responsive a lot of these owners are going to be.
Yeah.
So you might, it may be a complicated situation to universally change your method of delivering all of these statements or invoices of account to members, because you may have not recovered affirmative acknowledgements from every single owner attesting to their acknowledgement that you've changed this method of distribution. You also need to keep these affirmative acknowledgements as part of your official records, but it's not accessible to other owners to inspect. So this affirmative acknowledgement, while an official record of your association, to be kept with your official records, is not to be made available for inspection of the unit owners. Additionally, the notice of intent to foreclose upon liens in condos, which initially was 30 days, right? So you file your lien and you cannot foreclose upon it until you provide notice of your intent to foreclose. Now that notice of intent to foreclose lien has gone from 30 to 45 days. Additionally, with regard to statements of account or invoices, For all three associations, right, condos, co-ops, HOAs, if you send out a statement, okay, they must either go out by first class US mail or by email to the unit owner's last email on file. And before you change the method of delivery, the association must give 30 days first class US mail to the unit owner's address for mailing. And if they have a different address that is not the unit, then you also need to send it to the unit address. That's if you're going to change the method of delivering statements or invoices pertaining to assessments. Also, an association may not require the payment of attorney's fees in connection with assessments unless the association first gives notice to the owner of the delinquent assessments and provides that owner with the opportunity to pay those assessments exclusive of attorney's fees, right? And that notice needs to be, again, sent out first class US mail to the address on file for the unit. And if it's different than the unit address, to the unit address as well. And the statute provides the type of notice that goes out. So let's call this like the friendly notice, right? Friendly notice needs to be sent out before you slap on attorney's fees to an owner. You know, give them an opportunity to pay the delinquent assessment 30 days before you start tacking on the lawyer's fees. So be mindful of that. Also, the pre-lien notice, so the written notice that needs to be given to an owner before you can file a lien has gone from 30 to 45 days. Okay, so we're giving owners more time before we lien their unit. Instead of going 30 days, it's now 45 days. So that, in a nutshell, are the impacts of Senate Bill 56. There are a few more bills, which I'll try to just run real quick through because we're out of time. Senate Bill, House Bill 463. If you remember, it talks about those pools that you had to put, the suction in the drain and all that. There needed to be a special device put there so that we could protect against people getting stuck down there. Well, if you're in a community, an HOA that has less than 32 units and is not a public lodging establishment, then you are exempt from the Department of Health oversight pertaining to your pool, except as it relates to water quality and compliance with the anti-entrapment devices. Okay, so that is a clarification. This bill is effective July 1st, 2021. And it was adopted into law by our legislature and our governor. The next bill here, and if you just give me a second, is 1966, which was also signed into law, Senate Bill 1966, and has been and takes effect July 1st, 2021. It disqualifies board members from eligibility to run for the board if they are delinquent in their assessments only, rather than for other monetary obligations. So you know that before there was this provision that said if you're delinquent for payment of monetary obligations, you can't run for the board. Well, now it's only with regard to assessments. So those fines and other charges that might be owed to the association are inconsequential for purposes of disqualifying a board member or for disqualifying somebody from being able to be on a board of directors. Also, should a due date not be specified in the act, determines that the due date is the first date of the assessment period. It also requires a board to adopt an annual budget 14 days prior to the start of a fiscal year. Otherwise, it's deemed a minor violation, and the prior year's budget will continue in effect until a new budget is adopted. So those are the impacts of Senate Bill 1966. And the last two, which have been passed by both houses but have not been signed into law by the governor are House Bill 649 and House Bill 483. 649 pertains to if it allows for a community association to object to value adjustment board tax assessment. So it provides the mechanism for associations to be more active participants in the objection to the valuations given for ad valorem taxes imposed by the tax collector and the county appraisers. And so that is pending signature by the governor. Also, House Bill 483 is a bill that makes technical changes relating to the remote online notarization or the ability to provide for notarizations online and modifies the witnessing procedures and contains numerous clarifications in regard to that advance in our law. So that runs us, I believe, through what are the more critical bills enacted with regard to a community association perspective during this recent legislative session. I know we ran over by a few minutes here, but I wanted to make sure we at least discuss those last few bills, Ralph.
Sure, excellent. I do have a question with regards to the bill on the monetary amounts owed. So, in associations, in most documents, and the statute actually, it outlines the hierarchy of how assessments are applied. And, I don't remember specifically, but normally it follows attorney fees, late fees, interest, and so forth. And it goes down the line. How is that bill going to play into it if late fees or interest are the first ones that you're going to apply those payments towards?
Well, I mean, they will, the statute doesn't affect that
part of it
hierarchy. So
yeah,
remember, we are still nonetheless required to follow that pecking order once those amounts have been justifiably incurred. The issue is, as it relates to attorney's fees, for instance, an association cannot collect for attorney's fees unless that friendly notice has been given first. My presumption is going to be that most of our clients are all going to give that friendly notice, and we're just going to be more on top of it because, frankly, our ability to collect upon it depends upon whether you can assert, or file some type of legal action, and associations are likely not going to file legal action if they're not going to be able to recover attorney's fees.
Correct.
So it kind of becomes, a chicken or the egg kind of thing. But I suspect that we are going to be a little bit more mindful to those friendly notices. I think we're going to follow those deadlines. And then once we've given that friendly notice, all of those charges that we're entitled to collect for, interest, late fees, attorney's fees, assessments, are all going to fall in line.
Correct. Yeah, and I did want to stress that about Bill 56 because we're about a week away from July 1st, and some associations have already gone back on an aggressive collection policies. Some are just starting to get back into it, and this bill got signed on the 16th. So technically, as of July 1st, that's it. It's happening. There's no way around it. We need to be prepared. So for those board members and managers, make sure that you're checking in with your management company, or if you're self-managed, with your accounting firm and also with your attorney to get some advice with regards to the proper steps. You want to make sure that whatever process you're following, it's in line with what recently passed with Bill 56. I also did want to kind of wrap up. I know, Robert, you did an excellent job really touching up on many of the bills. And while we received many questions, I did want to stress that it's important that you rely heavily on your partners. And part of that partner is the law firms that we work with. So it's important that you reach out to your attorney to get clarification. Remember, there's a cost in doing business. We always get the pushback. Oh, do we always have to call the attorney? And, the wise tale is if you pay once rather than paying multiple times, if you get a lawsuit and so forth. So it only makes sense to reach out to your partners, to your attorneys, to your managing company, and have them, guide you through this process. In most cases, when it comes to these bills, we will be, reaching out to your association attorney so that they can give us the proper guidance and we have those opinions on file. So with that said, I think we've gone a little bit over. Robbie, I don't know if there's any closing remarks that you'd like to tell our board members and managers that are on the webinar before we wrap up.
No, once again, thank you to everybody for participating and for this opportunity once again. And if there should be any questions, of course, feel free to reach out. We're always here. You can go on our website, siegfriedrivera.com, and find all of our contact information and email addresses, and send that information. And be on the lookout for the summary that we will disseminate with regard to the topics discussed at this presentation.
Excellent. Thank you, Robbie. Well, for those of you that have a cell phone, if you'd be so kind to pull out your cell phone, turn on your cameras, and you can scan over the QR code. We will be placing this webinar on our YouTube page so you could share with your fellow managers or with your fellow board members. So feel free to subscribe to our YouTube channel. We do have weekly videos coming out, as well as we do post all our webinars. Ashley will be sharing the snippets that are provided by Siegfried with all of you that have attended here today. It'll also have Robert Blanch's contact information, his firm's contact information, in case you want to reach out to them for any further comments or questions, or if you want to hire them. It's been a pleasure, as always, Robbie, to work alongside you and your team, Stephanie, that has helped really behind the scenes. I want to thank you again. I also want to thank Ashley, who has been relentless in making these webinars happen. I want to thank my team as well behind the scenes who have helped her. Any questions with regards to management, please don't hesitate to give us a call. We're here to help in any way that we can. We naturally do it. We love to educate. We love what we do. So feel free to reach out to us. And we look forward to seeing you in our next webinar. Thank you and have a great day.
Have a good one. Bye.
Bye-bye.